India, as we understand it, is by nature a country of diametric plurality. We are not, in a sense, we can't really be seen as silos. And I talk about in the context of religions, not only between religions, but also between believers. Because under the same umbrella of different religions, you have different faith forms and different beliefs. And when you have these different beliefs, you will have three triads which we will have to consider. Inter-religious plurality, that is the multiplicity of coexisting religions. Intra-religious plurality, plurality of sects, schools, sub-traditions within a religion. And three, intra-individual plurality, which is, according to me, a very important one. The coexistence within a single individual of different faith forms. That is to say, as an Arya Samajist, if I go to a temple or a shrine, or a person who goes, an Islam believer will go also to a dargah, which is not really perhaps a pure form. And there are people who will go to Ajmer from different faith form, people who will go to Vaishno Devi different faith form. This is, therefore, it becomes a very interesting test as to what is your religious belief. Then, of course, there is the Puritan, who says, I will believe one and not another, and therefore we will have to deal with partial, eclectic, syncretic, or the Puritan believer, and all of those are going to be protected under 25. And the third tier, which is the tier of intra-individual plurality, is something which, with respect, has not been considered enough. Because when we talk of belief, we're looking at a belief form which may be multi-dimensional, not necessarily unidimensional. When we look at Bomai, and I've put that in my note with the paras, just make a note, it's written page 805, but see 801, there is an interesting passage in Bomai on secularism, which I want to place at this point. It's at volume 5.7. The judgment will begin at page number 531, and please come straight away to 801.
Volume 5.7.
Yes, 5.7. It's 531 at 801. Possibly PDF 80. PDF is also 801. Third line from the top. What's it called?
Judgment.
I'm sorry. Third line from the top. Second para.
Freedom of faith and
Yes, my lord. I'll just read not 4 lines at the top and 4 lines at the bottom of the para. Freedom of faith and religion is an integral part of social structure.
1 second.
Justice Ramaswamy's opinion, my lord. At page 914 of the report. इसके बाद next खोलो. It's on the screen as well, bro.
Okay, no problem.
Lord, it's at 801 801 of the running page and 914 of the report. And the third line is on the screen. Freedom, may I read it? Freedom of faith and religion is an integral part of social structure. Such freedom is not a bounty of the state, but constitutes the very foundation on which the state is erected. Human liberty sometimes means to satisfy the human needs in one's own way. Freedom of religion is imparted in every free society because it is a part of the general structure of liberty in such a society. And secondly, because restrictions imposed by one religion would be an obstacle for others. In the past, religious beliefs have become battlegrounds for power and root cause for suppression of liberty. Religion often provided a pretext to have control over vast majority of members of the society. Democratic society realizes folly of the vigor of religious practice in society. Strong religious consciousness not only narrows the vision but hampers the rule. Now please come to the bottom of that page, about 12 lines, 15 lines from the bottom. Matters which are purely religion. Lordship's got that?
Yes.
Matters which are purely religious are left personal to the individual, and the secular part is taken charge by the state on grounds of public interest, order, and general welfare. The state guarantee individual and corporate religious freedom and dealt with an individual as citizen, irrespective of his faith and religious beliefs, and does not promote any particular religion, nor prefers one against the other. The concept of the secular state is therefore essential for successful working of the democratic form of government. There can be no democracy if anti-secular forces are allowed to work, dividing followers of different religions, faith flying at each other's throats. The secular government should negate the attempt and bring order in society. Religion, in the positive sense, is an active instrument to allow citizen for full development of his person, not merely in the physical and material, but in the non-material and non-secular life. Hence, Pomai tells us that the state must promote religious tolerance, but also protect the right of each individual to follow their faith, which is personal in nature. Vivekananda mentions this very simply. Just keep a note of that. I won't read it. Just make a note. It's referred to at second bullet point on page 1. Vivekananda tells us,
issue directly and substantially under consideration in Bomai.
But Bomai, the issue was not directly, but the issue of secularism was raised. The issue of secularism was raised not because that was the issue, because the governments were being struck down on the ground that they belong to a particular political or particular religious persuasion. That was the issue. So it is not that it was untouched. It was relevant to that. It was relevant. It was not something completely dehors or completely irrelevant to the controversy in question. Now, Lord, I will take your Lordship a little further. And I'll just refer to, Lord, there's a note on Vivekananda, which I put in as the second bullet point, where he talks about men must develop beliefs. There are differences. I'm not going to read that quoted portion. I'll just tell you what it is. It's bullet pointed there. And the language he uses is interesting. A religion only like one set of fingers would be unnatural. We therefore see that if one religion is true, all others must be true. There are differences in non-essentials, but in essentials, they're all one. If my 5 fingers are true, then it proves that your 5 fingers are true as well. Whatever man is, he must develop a belief. He must develop his religious nature. Now, this is the context of religion, which we will have to take this debate forward. But we have to also keep in mind that in 1950, we had a game changer. We got the Constitution. The Constitution changed the rules of the game because the Constitution brought out a series of rights. Things which were not rights acknowledged to us by colonial masters became fundamental to us. It was a recognition of what had existed in us by the Constitution, and the Constitution we gave itself. We also recognize the need for religious rights, and they also form part of the fundamental rights chapter. And therefore, we must, for the first time, we must consider this, that religious beliefs therefore will have to be seen, but to test them. And I say this is, to test them is to understand the contours of 25, Is it to be seen alone, or is it to be seen in relationship with other rights, and to what extent? Now, what is religion? It's really a set of beliefs. And every time you have had change in a religion, you've had reform. Reform brings out a series of new beliefs. For example, Ramanuja, in Hinduism, Adi Shankara, the Arya Samaj in Hinduism. Judaism led to Christianity, led to the Orthodox Church, led to the Catholic Church, led to the Protestant set of churches. In Islam also, the Sunni faith, the Shia faith, and thereafter, there are various sub-branches. So wherever we go, there are movements, and the need to reform religion becomes very important. Sikhism, for example, is an eclectic mix of what some may say were Hindu beliefs, but also it draws a lot from the Sufi movement. You have more sayings of the Sufi saints. On one page in the Guru Granth Sahib, and I had occasion to see it, the word Ram comes 27 times. But Ram as an embodiment of God, not Ram as an embodiment of a certain God, but as the name of God. The point is this: in every religion, there has been a series of reforms and reform movements. So are we to say that religious beliefs are to be static? Absolutely not. And that is where the constitution come in, and that is where your lordships come in, and that is where parliament comes in. Therefore, when we look at the rights under 25, I wish to say this. 25 right is personal, it is subjective, it is conscience-based. It's a matter of belief, it's a matter of faith. Also stated by Vivekananda, also stated in Burmai's case. 25 does not contain the requirement of doctrinal purity. That will not come in 25. It allows me to believe, it allows me to profess and practice religion, not only imperfectly, selectively, but also in a Puritan fashion, in the purest form, where I believe that there should be no variation or no change. But when we see these rights in 25, when we see the belief forms that are protected in 25, we also remember that, as has been said by my learned brothers and sisters before, they're subject matter to public order, morality, health, and of course, most important provisions of Part 3. But these are words which are not surplusage. They are deliberately placed constitutional restraints in order to define the contours of what can be done in 25. This right will operate at 3 levels. Individual versus individual. My right to propagate my faith vis-a-vis her right to propagate her faith. We may be of the same faith. My right vis-a-vis the religious denomination, where I want to profess my right, but I'm told, like in the Parsi woman's case, sorry, you're no longer a Parsi, you're excommunicated. My right as the client I represent, a Dawoodi Bora lady who complains about FGM, about female genital mutilation. I'll touch about it in a little while, a little bit about it later. Who has been excommunicated? Her father has been excommunicated, her child has been excommunicated. Now, in such a situation, there has to be a protection of that right as against the religious denomination. And the third is the right against third parties. Can I do something offensive in my personal belief which will offend others or which will breach somebody's fundamental rights? Obviously not. It's like this: if I was to believe that manslaughter, that doing bully of a human being is part of my religious belief, would that be acceptable? Obviously not. It's murder. And that is the reason some of these rights, some of the issues that we are going to deal with are going to be excommunication, for example. And my learned friend Parmeshwar was telling me, don't open the IPC at all or the BNS. Excommunication for a matter is a form of wrongful restraint. Female genital mutilation, there's a whole series of offenses, and I'll show that to your lordship. Are we going to allow these practices which are violative of 21 rights? And there, I'm sorry to say, the debate of vertical horizontal will lose relevance, because am I not, if I am to be protected under habeas corpus, as your ladyship's minority view said in that judgment, in habeas corpus I have a right to be protected. Do I not have a right to be protected against bodily harm? And then let us come, therefore, as to what is the right of the denomination. Now, the denomination, and 26B therefore becomes interesting, protects the institutional rights. It tells us what we cannot do. It gives us a set of rules: inviolable, malleable, modifiable, because there has to be an upgradation also. But where the denomination goes beyond governing, goes beyond internal management and starts controlling the spiritual lives of its members to a manner where it goes beyond just guiding them, but constraining them in the exercise of other fundamental rights, I ask myself, would that be permissible? I believe it would not be. And let us also keep in mind, what is a denomination after all? The denomination is us. It is the individuals who form part of a denomination. There will be bodies, whether they are societies, there will be bodies, whether they are temples or institutions, there will be bodies across various religious institutions, which will all be comprised of individual members. If you were to throw out everybody saying that you don't follow the belief, there'd be a shell left of the denomination, there would be nobody left. Therefore, the denomination must be cognizant or sensitive to the belief of the individuals also and the rights of the individuals. Beliefs is one part, the rights is the other part. Otherwise, what we are really saying is 25, 26, which some friends have said on the other side, stand alone. The rest of the constitutional rights go out of the window. That is not the constitutional frame. That cannot be. And they can't even expect your lordships to do that. To ask your lordships to do that would be doing violence to part 3. The fact that 26 and 25 have been read together is the Devaru case. I don't want to trouble your lordships with that. But
Mr. Luthra, just for my clarity, does the Saudi Bohra community permit a person leaving that community? Because it's a belief. I can have a belief, but to be associated with that group where I call myself a Daudi Bohra is only when I do absolute obeisance or subjugate myself totally, 100%, more than 100% to the Dai. Can I come out of it? Suppose I say no. These things totally beyond acceptable limit, I come out. Are you permitted to do that? Or you cannot?
I'll just cross check. No. Yeah, there's no. I think not there's a restriction on leaving. I don't think there is a restriction on leaving to my understanding of it.
Then it does not lead to any penal consequences. Suppose if you leave.
But the consequence will be on the children. The consequence will be on the family members and the children. That consequence may happen as a separate.
I live with my family because only on puberty is that bond signed. Yes, you have to sign everything.
And what more? At 7 is the practice of female genital mutilation carried out. I'm not going to use adjectives for it. I'm going to tell you what it is. Just 1 minute. I'll just take a moment. So, there are.
Mr. Luthra, with regard to female genital mutilation, we need not go into all these other rights. The word health,
Yes,
public health is good enough
Absolutely.
to put a trump or to a bar or
I'm grateful for your lordship, but that's exactly what I'm saying, Lord, because and that's the reason, Lord, I was just telling your lordship, I was not responding to that query. Not the issue is simple. The nature of the injury is that the clitoris is either the skin is either removed, and that has about 10,000 nerve endings. 10,000 nerve endings
Irrespective of
at the age of 7.
irrespective of the fact that this is a mutilation of a vital organ of a female body or a person's body, and it impacts her health, reproductive health,
Absolutely.
physical health, etc.
Emotional health, not autonomy.
The word public health would definitely be
Yes, ma'am.
impacted if this.
Indeed, my lord. Indeed, Lord. Indeed, Lord. My lord, that's absolutely right.
Can touch upon morality also.
Yes.
But morality,
For what purpose it is done?
that's the issue.
There it touches morality.
Absolutely. It touches morality. The question is, it is a practice which is going to curtail a series of rights, not just one. And it falls within various sub-brackets. And I must tell this court, it is even in this country. It is followed not amongst only this community, it is also followed amongst a section of the Sunni community in Kerala. It is followed amongst, it's a religious practice. It came from Judaism times. It is followed by the Coptic Christians. It's followed in sections of the Jewish community across the world.
Antiquity, expression of religion, etc. It is to be subject to public order, health, and morality. And we do not see how an act which intrudes into individual physical autonomy, mutilates the vital organ of the body, would not fall foul of these
Absolutely.
expressions.
And an act not more crucial.
And as you say, a secular law like the penal code,
Yes.
making an act of mutilation of the body amounting to hurt or grievous hurt would be in the form of an 25(2)(b legislation, although it may not be a specific legislation of reform, but would definitely
Yes, Lord.
eat into the.
In fact, Lord, I'll just
Religious.
pass over. It falls foul of as many as 3 statutes. Lord, just see that for a moment. I've made a one page.
Even otherwise, Mr. Luthra,
Yes, my Lord.
mutilation, but the word itself means that it does not serve any purpose. It is to contort. It's like a contortion to a human anatomy. Had there been some benefit attached, because a lot of practices are there, but those are for the good. But this here is pure aberration to a normal physical human anatomy.
And I'll tell your Lordship where the anguish comes in. It is done at the age of 7, when a person is a minor incapable of giving consent, and because it is considered to be part of a belief system, though not ordained by the Holy Book.
So that is mandatory and fundamental here. This is mandatory and fundamental under the Dawoodi.
That's the claim. And kindly just see this chart for a moment. It'll fall within hurt, grievous hurt by dangerous instrument because it's done performed using blade, sharp instrument.
Mr.
Grievous
Luthra,
hurt.
one clarification.
Yes, my Lord.
When it's a 7-year-old child,
Yes, Lord.
it's the parents
Yes.
who naturally.
Parents or family members or relatives.
Naturally are members of the Dawoodi Bohra community.
Yes, Lord.
They required to give the consent with regard to this. And would it be if they don't give consent, they will be excommunicated?
Yes, ma'am.
Okay.
And not the issue is this today. Today we have one litigant, my client, and a few more who are willing to talk about it and have suffered excommunication. The challenge is this, that a lot of these issues that will go on behind closed doors. And that is what we have to address. Lord, today, Lord, that is, just see for a moment, and your Lordship will see, Lord, hurt because it causes bodily pain, injury, and physical suffering. Why? And I put it in the right. My colleagues have done a hard work, Lord.
Is there any need to tell all this?
No issue.
Everybody knows.
No difficulty, Lord. I just put it in the sections that falls in, Lord, and POXO is a Juvenile Justice Act also.
No, you have done well that you have
Summarized
hide.
for your Lordship.
That's all.
Just a summary, Lord. I don't need to get into details. That's what I said. Now, Lord, just to come back to what I was saying. Now, the tendency in religious freedom jurisprudence has been to, counterpose, not all the historical cases are, the denomination against outsiders of the state. A law comes in, the denomination says, look, this law is harsh. They challenge it as against state action or against third parties. Today, what we are looking at is the counterposition, where the rights of the individual member are impacted by the denomination. As I said, the Parsi woman's example are 2 stark examples before your Lordships, and the Dawoodi Bohra woman's example, which is another stark example. Both have lost their identity and their rights to be part of the community, to participate in the community, to even attend the religious ceremonies. And the Parsi woman's case, Lord, the ability to attend your parents' last rites.
So is there no law banning this mutilation?
No specific law. No specific. No. I must point out. 59 countries have banned it in the world. In India, there is none. 59 countries have banned it. In 2 countries, there are judicial decisions. One is Egypt and one is Australia, which have given decisions by judicial decision making. There has been a ban.
Mr. Luthra, you are specifically on this issue only.
On these 2 issues. No. I'm on these 2 issues. One is the Parsi woman's right. The Parsi woman who gets excommunicated on marriage, and then the FGM. But as I said, I'm not going to dwell on the facts of these cases. It has already fallen to the Chief Justice.
For FGM, the argument will be substantially in a different direction. That will be more pointed and
My Lord,
slightly off track from the main general.
My Lord, in fact, I must tell your Lordship, I'm grateful your Lordship has said that. In both cases, the effect is excommunication is one of the commonalities. It's a common consequence of it. One is by doing a physical act, the other is by restraining me from access.
Impact of consequence. What was the issue?
Yes, ma'am.
But all these,
This is where you are challenging Saidna's ratio. That if female genital mutilation is a part of matter of religion and that affects physical health of the woman,
Yes.
and that minor child
They allow this to female genital mutilation to happen.
so it's not necessarily that secular act is only which results in excommunication,
Yes.
which needs to be looked into.
Absolutely.
But certain religious practices making serious intrusion into physical
Bodily health, autonomy, sexual health, mental health.
Double impact.
Yes, my lord.
Physically causing all these things to a person at a very young age.
Yes, my lord.
And secondly, also the impact on the parents if it is excommunication, then their social, they are cut off from the society. So this double impact.
Indeed, my lord. Indeed.
Emotional is third one.
Yes, Lord. And mental, Lord, because this is a trauma, it also impacts your life. It impairs you for life because it is something, Lord, it's not like, I must tell your Lordship, it's not like an injury which can get reversed.
Exactly.
Today, I must tell your Lordship, we have a senior plastic surgeon in the family. If a hand is cut off within few hours, you can join it back.
It's some-
But once the nerve ending flow,
something-
they're gone.
Certain
If something like your tongue is cut off,
Absolutely, Lord. It's gone.
it's not going to regrow.
Absolutely, Lord.
serious.
Lord, it is a belief.
It is purity.
It is a belief. Lord, it is purity. It is control,
The
Lord.
sense of challenging woman's sexuality,
Absolutely, Lord.
identity.
Identity, autonomy, sexuality, control.
Here impact will be multifold.
Absolutely, Lord. Absolutely. Yes. Now, Lord, therefore, as I say, when the right of the denomination comes in conflict with the right of the individual believer and it curtails its fundamental rights, then the balance must tilt in favor of 25 and cannot remain in the contours of 26. That's the point I was seeking to make. Because denominations,
supplement with one word more,
yes, my lord,
that even the expression right becomes a very complex question.
I'm
That
grateful.
what is
Lord.
the right that a denomination will possess that, or an individual will possess? That right itself also becomes worth defining.
Lord, your lordship has not put it better than I will, then therefore I will not dwell on it. I will just touch upon one aspect of the matter, Lord. Keep one thing in mind. There will be three levels where you will consider it. One is at the level where the community or the denomination impairs a minor's rights. That's really simple. Because when it's a minor, the question is lack of consent, that the matter goes on. A minor can't give consent. Then the question is the power relation. Even in the context of sexual offenses, we realize that power equations are treated as a more severe form of breach. That's the recognition which we've had across the board, even in the context of the workplace where you said power equations create a problem. Therefore, we had Vishaka's judgment. So today, my submission to your lordships is whether it be minors, whether it be individuals, we are pitching the mighty denomination against the individual believer. And if the individual believer, not today, feels oppressed by such a practice, are we going to quibble on the issue of whether it is essential or not? Or are we going to say it is violative of 21, 19, 14 and are we not going to throw it out? So this is where I really want your lordship to consider it. Now, not the next section.
Within Article 25(1) itself, the riders are there.
Absolutely. But then 26B has to be read. Therefore,
That is also with the same riders.
it has to be read. It has to be read. No, but it also has to be read.
Sir Luthra,
So, yeah.
what my sister is saying this is this. 26B would come over a religious practice which is otherwise acknowledged,
Yes.
unless the state feels it's a case of social reform or social welfare. But 25(1), though it's a positive act, it limits such a right, positive right, that's right. Therefore, you can't even do, that's what the sister is saying. If you can't do, then it is not open even to think of doing it. It will not come. The second part we say about conscience, freedom to a proper practice, it will not come within the bracket, is what sister is saying. Therefore, it is better for you to bring it under 25(1)
Yes, Lord.
than to rely upon anything else.
Lord,
That's what.
Under 26,
I am very clear.
the same three riders are there. Public order, morality, and public.
Leadership, I seek to go a little beyond. Because 25(1), my rights are there, which is subject to part 3, and I am the believer which forms the denomination. 26(b) has to be read as it fallen from your lordship cohesively. It can't be read disjunctively. That's
What we are saying.
I understand.
The practice itself cannot even be
Absolutely.
followed. Yeah.
I completely, Lord, I completely
No,
concur with-
Mr. Luthra,
Yes, Lord.
if I've understood the final point of argument, probably you are giving us a very novel proposition. If I've understood you correctly, I'm just explaining myself. You mean to say that even otherwise, on this touchstone of the overall constitutional safeguards to a citizen, which is unalienable and fundamental, even DHOS 25, 26 to that extent cannot be given effect overriding the individual. So it is,
Yes, Lord.
6 here may not be dependent on 25.
Yes.
Even if there is no interplay still, even on 26, that guarantee cannot be enforced, especially in these matters. Is that
Yes,
the
that is one part of it.
it's slightly a shift from the main. It is not directly, it doesn't have to be directly dependent on 25.
Lord,
Independently also, those practices or those aberrations have to be taken care of, and the court has to intervene in judicial review.
Lord, and I must tell your lordship, that is the reason I said when we deal with minors, when we deal with people who are, I would say, less privileged because they don't have the ability to come to court because of the consequences that befall them, is it not, I ask myself, is it not part of the access of justice that I can come to the court under 226 or 32?
So what
Because
will
if
be the
I
effect?
don't, where will I go?
What will be the effect ultimately we revert back to as my brother is asking, the effect is that if you refuse to obey this perceived religious dictate, the consequence is your excommunication.
Yes, ma'am.
And therefore, question of relevance of 1949 Act comes into, and the view, how it has been upheld through para 61 by Justice Iyengar's view, that becomes subject matter of reconsideration. We understand this probably.
That's the point.
Nothing
That's the
more
point.
you
I just
That's
need to
the
clarify,
point.
this is not one of the grounds of excommunication. I just,
Not a ground.
this is not a ground for excommunication. And also, Lordship, factually, of course, the fact that it's not mutilation, the fact that it's a wrong description of the practice,
But we-
that's separate. But this is not a subject matter of excommunication for sure. So that's factually
May I
incorrect.
just-
No, Lordship,
Please,
nobody gets excommunicated.
Yes, please clarify this.
Lordship, please.
She's been
If
excommunicated.
parent, father
Lordship, please.
of a minor 7-year-old girl refuses to go through this process, will he be in breach of the dictate of the die or not?
Lordship, there is no temporal consequence for a spiritual act. Like, for instance, if I'm not offering namaz, there is no punishment for not offering namaz, no matter how mandatory it is. Therefore, there is no excommunication and there is Lordship, please.
Offering namaz. It's a question of doing an act in breach of the dictate of the die.
There is no worldly consequence, Lordship, in the Dawoodi Bohra faith to this non-adherence to this practice.
Pacha,
Lordship, please.
consequences are there because the Act says so, 1949 Act says so, Supreme Court judgment says so,
In
consequences.
religion, there are no consequences, Lordship, is what I'm saying. So no excommunication, no religious sanction.
There are no
So
consequences.
is it an optional thing?
Lordship, that's why I took the other example. It may be mandatory, but that doesn't mean there is a worldly sanction behind it.
The moment it is mandatory, mandatory refuse.
That is sufficient.
How can it?
Ah.
Lordship,
You answered the question.
it's like circumcision for boys. There is no worldly sanction for anybody who doesn't get circumcised. However mandatory it may be. It's an individualistic practice. It's
From
a
a public health point,
Lordship,
there
please.
is a clear difference between circumcision
Absolutely.
and a genital mutilation.
Lordship, and so it's actually on facts that this question is being met because it's a wrong description. It's not mutilation. It's actually symbolic circumcision.
Genital circumcision of the clitoris.
Lordship, which is called,
Cannot be equated to circumcision.
which is called,
of the
it's
male.
called hodectomy in the West, Lordship, and it's on the facts of the practice that practice is being, this argument is being met.
No, what is the object of it?
Terrible.
Lordship, the object in the religion is to increase the sexual pleasure for the woman because the opening of the tissue on the prepuce of the clitoris helps to increase pleasure. It's called,
Talking.
It is to suppress
your facts
the
clear.
sexual
Lordship,
activity
It is
of
just
woman.
the opposite.
Lordship, in fact, there is a practice called hodectomy in the Western world.
Mr. Pasha, I'm very surprised you use the word analogy to circumcision. Circumcision is a sunnat of the Prophet.
Lordship,
It is not mandatory. When
Lordship-
it is mandatory, kindly get your facts correct. Don't use it so loosely.
Lordship, it's
Connected with the circumcision.
Lordship, so the Dawoodi Bohra faith treats that injunction as
Limit yourself to
children.
Dawoodi Bohra. Don't come on the basic Islamic.
Lordship, no, I'm only on the Dawoodi Bohra faith, Lordship, because I represent, in this matter, I represent
Circumcision.
the community.
Use comments on a religion.
There are 60,000 women from the Dawoodi Bohra community who have formed an association to come and represent before my lords. I speak for them.
You take use it.
Back to a pure legal question of law, that legal question, pure question of law, reverting back, as we were just winding up before lunch, we're saying that when we were reading the majority opinion,
Lordship,
upholding, striking down the 1949 Act,
Lordship, please.
we were just indicating that the doctrine of severability could be applied
Lord-
by that at that time.
Lordship, please.
And therefore, to the extent the Act was not meeting with the principle of proportionality,
Lordship.
that could be struck down.
Lordship, please.
And to the extent it was within permissible parameters could be upheld.
Lordship, and this
Therefore,
practice,
Test of reasonableness should have been applied instead of going with just one hammer that because it violates 25, 26, strike down.
and Lordship, this practice is not covered by excommunication. There's no excommunication for this practice. I want to clarify.
That's why right now we are afraid of going into facts, individual facts.
That's right, Lordship.
General principle.
That's right, Lordship. So therefore, the description of the practice and the fact that it's mutilation, all of it, we are meeting on facts. But on the
We are only evaluating on the premise on hypothetical basis that if it were to be a practice, then what is the consequence?
Lordship, so no excommunication for this practice.
That is practice. If you refuse to follow this practice, then it is excommunication. And
Not at all, Lordship.
Excommunication, then question of 1949 test comes.
Not at all, Lordship. That's the categorical submission on instruction that there is no excommunication.
It's mandatory,
The
mandatory.
moment it is mandatory,
It's
Yeah.
mandatory.
it has to be judicial. It has to be.
Lordship, it's-
Unnecessary diverting. Excommunication, maybe divorce of excommunication, the moment it becomes mandatory, then we have to test whether it is justified, whether it can be.
Anything
For the
else?
Constitution of India and in India.
10 minutes more, Lord. 7 minutes, but just 2 points. No, not 2 points, 2 more points, and not 5 to 7 minutes more, and I'll conclude. But therefore, as a consequence, I say, no denomination can seek constitutional protection. Just as not, though I can seek the right, the denomination cannot seek constitutional protection for practices which would fail on the anvil of fundamental rights. That's the point I wanted to make.
Pardon?
No denomination can seek constitutional protection under 26B for practices, if examined by the court, would fail the test of fundamental rights because of 25(1). That's the point I wanted to make as a consequence of all of this.
That will depend upon case to case basis. That may not be generalized as.
Lord, I'm making a legal point on this. My Lord may consider it.
Fine.
Now, Lord, therefore, as I say, that Narasu Apu Mali will have to be put to rest, as there have been observations that you can't keep the provisions on faith outside and untouchable against the fundamental rights chapter. And I'll leave this part. Now, Lord, the last 2 points that I wanted to make to your Lordship were this. Firstly, Lord, there will be an issue on the nature of jurisdiction. It's a question you've asked many times over as to who can come, who cannot come. The point is this, as I said earlier, if somebody does not have access, this court has parents patria jurisdiction. You've exercised it many times over. Not only that, when it comes, as in the Parsi woman's case, against a society, because the trust is a society, the body is a society, to not allow it to protect these rights your individual rights of belief, Lord, would make it completely, because what they exercise under 26B is a public duty. Under 26B, it's not a private duty, it's a public duty. Therefore, 226 and 32 are therefore by implication clearly made out, and that's the point, Lord. I've given the judgments of Andi Mukta, BCCI, Kaushal Kishore. I don't want to say more. The last point before I conclude, Lord, is this. There is an issue of constitutional morality, social morality, and I want to tell your lordships, we will have to test anything in law, not by social morality, not by majoritarianism, but by critical morality. That is to say, social morality will be plural by nature. Critical morality is what the law ought to enforce. And here, the grand norm is the Constitution and the Fundamental Rights chapter. And therefore, it is critical morality which you are called upon, Lord. Even when a legislator is asked to represent his people and be the voice of his people, and I talk of a legislator, the legislator is still bound by the oath on the Constitution to uphold the Constitution and the laws. He or she cannot go beyond that into violence to the Constitution.
So that both sides are broadly agreeable.
Yes.
That constitutional principles are actually known as constitutional morality.
Yes.
That whosoever hold in a position and responsibility, that he must adhere to those constitutional responsibilities.
Yes, Lord. But therefore, I will leave your lordships with not just one quote which I want your lordship to read, and I'll finish with that. And just take this one out. Just see this for a moment. Lord, just see. This you will find. Is it being uploaded?
Yes.
Really?
Page number. Okay.
6.1.8 of the compilation I've tendered today, Lord, page number 16. I'm just going to conclude by reading this, and 6.1.8, Vivekanand, Lord, says,
Page.
Lord, it's page 16 of my compilation, Lord. This will be in the compilation. In be page 21 in your lordship, Lord, it's been uploaded today. Ma'am, we'll have to ask the mic as well. It's been uploaded.
Yes.
Uploaded.
6.1.8.
It'll be in the compilation, Lord, not here. It will be in 6.1.8 of the compilation. 6.8. Volume 6.8. Volume 6.8, Lord. Volume 6.8. I'll read it.
Page.
Lord, it's page 21 of volume 6.8. Just make a note. The question is there a way out? To put it in a more concrete form, is religion to justify itself by the discoveries of reason through which every other science justifies itself? Are the same methods of investigation which we apply to sciences and knowledge outside to be applied to the science of religion? In my opinion, this must be so, and I'm also of the opinion that the sooner it is done, the better. If a religion is destroyed by such investigations, it was then all the time useless, unworthy superstition, and the sooner it goes, the better. I am thoroughly convinced that its destruction would be the best thing that could happen. All that is dross will be taken off, no doubt, but the essential parts of religion will emerge triumphant out of this investigation. Not only will it be made scientific, as scientific at least as any of the conclusions of physics or chemistry, but will have greater strength because physics or chemistry has no internal mandate to vouch for truth, which religion has, unquote. I'm deeply obliged, Lord, your lordships have been very patient and kind, and grateful for the hearing.
Thank you.